Hello, everyone, and thank you for joining us for today's educational seminar. This is another extra special educational seminar because in addition to our PILI interns and fellows joining us today, we have some PILI advisors and pro bono volunteers joining us for today's program, advocating for pro bono and legal aid LGBTQ plus clients. LGBTQ plus people face unique challenges navigating the legal system. So today we're going to learn about current issues, common challenges, and ways to advocate for LGBTQ plus clients. And I'll pass Jessica to talk about some details of it for CLE and then introduce our speaker.
Thanks, Brent. I'm Jessica Schneider. I'm one of the managing attorneys at PILI, and I work with our pro bono programs. Thanks to everyone joining us, both interns and fellows, and also our pro bono attorneys who are here for the virtual pro bono CLE series. This is the final one in our first part of our 2021. So thank you all for being here and for joining us. We are going to hear from Nora Huppert, who's a Renberg Fellow at Lambda Legal, which is the oldest and largest national legal organization committed to achieving full recognition of the rights of LGBTQ people and everyone living with HIV. And so Nora has some extensive knowledge in this area and is going to be speaking to us about those issues. So I am going to pass it over to her.
Thank you for that. And I don't know how extensive my knowledge is, but hopefully extensive enough to say something interesting for everyone today. I'm just going to try to share my screen to get this PowerPoint up. Okay.
Yep.
Great. So I just wanted to start off by speaking a little bit about sort of recent developments and current work in sort of LGBTQ rights litigation and policy a little bit as sort of an overall theme. And for those of you who might work in this area or have just been following it, some of this might be a bit of a refresher, but hopefully interesting nonetheless. So just a little bit of background about Lambda Legal. As was said, we are a national legal organization that fights for the rights and recognition of LGBTQ people and everyone living with HIV. Mainly our focus is impact litigation, although we do a fair amount of policy work as well. I have been with Lambda Legal for a few years now and have worked on challenges to healthcare exclusions that exclude coverage for transition care, identity documents challenges to policies that ban correction of gender markers and names on documents for trans people, cases involving discrimination in schools, and so sort of the whole milieu of LGBTQ rights sort of issues at the national level now. So to give a little bit of background about recent developments and sort of what's new, and again, I think for anyone who sort of closely follows this area, some of this will be quite a bit of sort of retreading ground, but I just wanted to sort of lay a foundation for what the landscape looks like right now. There are, I would say three main recent developments. One being the Bostock decision at the Supreme Court last summer. The other being sort of policy changes that have come in with the Biden administration, sort of dovetailing with implementation of Bostock, sort of across the larger milieu of civil rights protections at the federal level. And then sort of this new, incredibly toxic anti-trans sentiment that sort of has been overtaking the state legislatures this year and a little bit last year as well. And that's not to say that force hasn't been present in years past, but it's clear that there's been something of a pivot to just sort of direct energy towards harnessing a legislative appetite in states for anti-trans legislation. So to talk a little bit about Bostock, Bostock was came down last June, Pride Month, just a little over a year ago. The holding of Bostock was sort of multifaceted and complicated. I think for purposes of this presentation, we can just say that it held that Title VII, being the federal civil rights law that protects against discrimination in employment, reportedly, that those provisions, which already protected, as a matter of the statutory text, protected against discrimination because of sex, that provision also protects queer and trans people, or protects people on the basis of sexual orientation and gender identity from discrimination in employment. This is just sort of the key quote there. An employer who fired an individual for being homosexual or transgender fires that person because of traits that would not have questioned in members of a different sex. And that's sort of one pillar of the argument that Lambda Legal and our sister organizations have been making in the courts of appeals for many, many years. There's lots of different ways to get to the conclusion that sex discrimination includes sexual orientation and gender identity discrimination, but that's probably the simplest way. And, you know, before Bostock had been decided, there was a pretty quickly solidifying consensus among the federal courts of appeals that this was the case, not just in the Title VII context, but as we'll talk about later, in many other contexts, that sex discrimination included sexual orientation and gender identity. But Bostock solidified that interpretation and also sort of gives us a very solid ground for importing that pretty inescapable reasoning into other anti-discrimination contexts. So with the change in administrations, you know, as I sort of mentioned before, many courts already understood sex protections to include LGBTQ people in all kinds of different contexts. So in Title IX, we had already had decisions like that in the Grimm case, and also in one of Lambda Legal's cases, the Adams case in the 11th Circuit, that Title IX sex discrimination protections also covered trans people in schools, for example. There have been gender identity protections in credit, actually, for a few decades now, one of the very first sort of areas to have that extended. And as many of you may be aware, there's not really a federal sex discrimination protection in public accommodations, but those protections exist in many states. And so often the state will either explicitly protect on gender identity, or the same sort of reasoning as was in Bostock will apply. But you know, this idea was not sort of uniform. And so over the past year, implementation of the holding of Bostock across different discrimination contexts has sort of unfurled. Day one of the Biden administration, there was an executive order instructing agencies to apply Bostock sort of across the board. And different components of that was just a few examples here. The Title IX memo in April, and the CFPB interpretive ruling in March, but there have been, you know, quite a few of these since the change in administration that have just sort of confirmed that sex discrimination includes sexual orientation and gender identity, not just in Title VII, but pretty much across the board. Other sort of consequences of the change in administration has been sort of the re-implementation of the sexual orientation and gender identity aspects of Section 1557 of Obamacare, the Affordable Care Act. Section 1557 was and is a key provision of the ACA that protects against discrimination in healthcare. Getting kind of in the weeds, but it just uses the enforcement mechanism by statute of pre-existing federal civil rights laws. So, excuse me. So the Obama administration had kind of correctly already understood Section 1557 to include queer and trans people, and indeed Section 1557 was a pretty important tool to, in particular, to sort of provide broader access to transition care for trans people, and to sort of go after discriminatory insurance policies. The Trump administration obviously had drastically scaled this back, but with the Biden administration, things are sort of in flux. But the basic point is that the bad Trump rulemaking has been undone, and so the sort of administrative side of Section 1557 is at least good again. But the statutory sort of parallel was unchanged by the Trump administration's actions. And so this whole time, the ACA has at least been available to private litigants to challenge, say, insurance plans, provided that other elements were present. And this is just sort of a little blurb about the repeal of the repeal, and OCR's sort of interpretation of Section 1557 going forward. So when we talk about this, what I think is probably sort of most urgently on my mind and many of my colleagues is this current wave of really, really toxic anti-trans sentiment in state legislatures. There have been over 200 anti-trans bills filed this year, depending on how you count. And it can vary wildly depending on how you count, but those bills have sort of taken two major categories. The first being these healthcare bans that many states have introduced, generally pretty widely constructed, and often criminalize the provision of transition healthcare, usually to adolescents, even when medically necessary. And some of them are written even as broadly as to criminalize just sort of encouraging a young person to sort of explore their social identity, and sort of at their broadest could be interpreted to criminalize, saying encouraging a child to sort of dress differently or groom differently, things that we refer to as like social transition. And the second major category has been these bans generally on young trans women in sports. As you see, there's been quite a few. These are not comprehensive lists, by the way. These are just a few examples. And then there's been sort of a additional bucket of just various miscellaneous pieces of legislation. We've seen a few birth certificate bills banning corrections of gender markers on birth certificates, state RFRAs. A particularly egregious sort of one-off example was Tennessee's bathroom bill, which was enjoined on First Amendment grounds a few weeks ago, which is good. But for those of you who haven't been made aware of this particular law, this is the sign that the law requires businesses to post if they sort of don't require trans people to use the bathroom that corresponds with their sex assigned at birth. It sort of has a deeply worrying historical element to it, but was enjoined recently. So where does that leave us for sort of having gone over some of the background? Where does that leave us now? I sort of want to talk about drilling down on trans rights and talk about sort of some of the litigation and policy efforts that have happened around this sort of wave of anti-trans legislation, and then talk about probably one of the sort of biggest focuses of the work of organizations like Lambda Legal being sort of access to transition care as a matter both of like anti-criminalization as well as just sort of ensuring broader access by sort of fighting discrimination in healthcare settings, as well as crucially in healthcare plans. So Many of these anti-trans bills that were filed were defeated in state legislatures as a matter of policy. It really seemed like sort of anti-LGBTQ forces this year were just kind of throwing a lot at the wall to see what would stick. There were a shocking number of bills filed, and only a small number that were actually enacted. Pretty dramatic example of this was the South Dakota sports ban. The governor had sort of made the ban on young trans women in sports, in school sports, sort of a signature issue for her. She seemed to, from an outside perspective, see it as like a springboard to like a national sort of audience. But at the last minute, sort of almost basically abandoned the legislation. She sent it back with changes and basically killed it, at least as a matter of legislation, and trying to sort of implement something through sort of executive policy, but at least the law was ended essentially. And ostensibly this was because she had been convinced by those in the know that the policy was unconstitutional, and which it was, and would lose in court to organizations like Lambda Legal and the ACLU and others, and that it would involve spending legal fees defending it. I don't know that I buy that, because that hasn't seemed to stop anyone before, but at least as a matter of the state of it right now is it's dead. There's been some litigation already over bills that have been enacted, even though many of them are just now sort of coming into effect. A lot of these state bills have had a July 1 effective date. One of those is because it was a bill that was actually passed last year. Idaho sort of got the jump on a lot of other states when it comes to discriminating against trans people. They passed these two anti-trans bills in March of 2020. One of which we'll talk about later, which is a birth certificate bill, which is a case that I worked on at Lambda. And then another is the ACLU's Hecox case, challenging the very first trans sports ban, at least in the form that we know it now in the country. And that was enjoined on equal protection grounds. It's on appeal now in the Ninth Circuit. So it was a really good decision, and it sort of remains to be seen what's going to happen with it. And then literally about 24 hours ago, almost exactly, the first two sort of challenges to these new laws resulted in injunctions. One was Lambda Legal's case on the West Virginia sports ban, and the other was the Arkansas healthcare ban, which was both of which were enjoined in federal court yesterday afternoon. So the state bills that I've sort of been talking about, many of them involve the criminalization of the provision of transition care, but criminalization is really only half the conversation when it comes to access to transition care for trans people. The other half being exclusions. In other words, insurance policies or policies in sort of public healthcare plans that exclude coverage for transition care for transgender people. Comes in many forms, especially in its most outdated. We sort of see language like sex transformation or sex change, but the basic point is that these are outdated discriminatory policies that refuse to cover transition healthcare. There are a few tools that we use to fight these policies. One of them is Title VII, because of the sort of peculiar privatized healthcare system that America has. People tend to get their healthcare from their employer, and courts have obviously long understood sort of employment benefits to be covered by Title VII and to be sort of challengeable when discriminatory. And so we often use Title VII to challenge discriminatory healthcare plans when they're provided by an employer covered by Title VII. When the state is an employer, Title VII and constitutional arguments are often available. sometimes, as we'll get to, I think in like the next slide, Section 1557 can be available depending on the situation. And so Title VII has been kind of a mainstay of, in particular, challenging state employee healthcare plans that are discriminatory. This is just a sort of a list of a few examples of those plans. Lambda Legal, for example, in Alaska, last year successfully challenged Alaska's state employee plan and their exclusion. We represented a transgender state librarian in Alaska who was unable to access surgical care. These are just a few examples, not by any means a comprehensive list. And there is definitely ongoing challenges to many of these sort of exclusionary discriminatory state employee plans. Section 1557 is another available tool to challenge discriminatory exclusions. Again, Section 1557 is sort of the anti-discrimination tool within Obamacare in healthcare settings and in the provision of healthcare. This sort of, the second bullet is just sort of a broad view at some of the kinds of, discriminatory, the sort of arguments that we make to point out how discriminatory some of these policies are. And at its most narrow, we can recognize that a policy that covers certain care for cisgender people or people who are, say we're talking about coverage for a trans woman, an insurance plan that covers the same care for cisgender women who are assigned female at birth, but denies coverage to transgender women who are assigned male at birth, is a pretty clear example of both gender identity and sex discrimination. Hormone replacement therapy is usually like the clearest example of that, right? Estrogen, testosterone, and anti-androgens are frequently prescribed to cisgender people for a variety of medically necessary reasons, and plans that cover that care while denying it to transgender people are pretty clearly discriminatory. But obviously the same arguments apply to surgical care and that sort of thing. The difficulty with Section 1557 being sort of open questions around who's covered, in particular, the sort of federal funding aspect of it, which has kind of gone back and forth with the Trump sort of drawback and then the sort of repeal of the repeal. There's a sort of, it's sort of in flux, and the sort of the question of like, what aspect, especially when you're talking about the government, sort of what aspect of what aspect of the government is receiving the federal funding sometimes becomes pretty important. And then this is just sort of an overview of some of our Medicaid litigation challenging, or ours and other sister organizations, Medicaid litigation challenging exclusions in state Medicaid programs. Here, we've seen Section 1557 claims because these are often programs that are vastly funded by the federal government in very large numbers, and obviously involved in the provision of healthcare. There are also equal protection claims, and in some cases, Medicaid Act claims, the comparability and availability requirements, which has we've seen in cases like FLAC, and has been at least included in other challenges. And again, this is just sort of a non-comprehensive list of some of the Medicaid litigation. The Alaska case and the West Virginia case are sort of Lambda Legal challenges to Medicaid exclusions. And then I thought I would just sort of include, which might be useful, for this audience, just a sort of basic read of the healthcare protections that exist in Illinois. As we might expect, there are express sexual orientation and gender identity protections under Illinois law in healthcare and elsewhere. So these are just the Illinois Human Rights Act statute that's relevant, the health insurance regulation that's relevant, and just to mention that there is Medicaid protections and coverage for gender affirming care in Illinois as of January of last year. And then this is just sort of issues unrelated to sort of the anti-trans bills that we've talked about and the healthcare exclusions. Definitely problems that sort of affect a great many trans people is just sort of a workaday matter. Identity documents. There are in many states pre-existing and some new as of this year bans on birth certificate gender marker corrections. And an increasingly shrinking number of states still impose some kind of surgical or medical requirement for either or both of sort of state ID, meaning driver's license, or birth certificate gender marker changes. But then we've also seen X markers become available in a few states and recently at the federal level in passports. And then we've also seen some movement on incarceration. There's been a growing number of states that have implemented housing protections for trans people inside, allowing for housing placements based on gender identity and that sort of thing. And sort of what are the growing threats in this area besides just in general the number of new attacks at the state level? One is sort of this growing, I think, willingness to flout federal court orders among the states that really want to discriminate. We saw this with HB 509 in Idaho, which was the Idaho birth certificate law that I mentioned earlier. That was a Lambda legal case, and we had won a permanent injunction in 2018 requiring Idaho to allow for gender marker changes. And then in March of 2020, the legislature passed a law and the governor signed a law ignoring that federal court order by banning gender marker changes again. And obviously we had to go to court to enforce the injunction and make sure that that policy wasn't implemented. But it's a worrying development for sure. And then at the federal level, we've definitely seen a pivot in legal arguments towards expanding the ground for religious-based and other sort of First Amendment exemptions to basic anti-discrimination principles. So what does all of this mean for serving trans people as clients? Thinking especially of those of you who might work with trans people sort of needing services for reasons not directly related to their identity, but who might nonetheless be dealing with very serious personal issues. I think the first is healthcare needs. Both in terms of whether they're currently excluded or being denied access to transition care, as well as just discrimination in healthcare settings apart from transition care. In other words, do they have access to primary care? Do they feel comfortable going to an ER if something happens? That sort of thing. Discrimination in healthcare settings against trans people is incredibly rampant, and deterrence is a huge element of that. I can't tell you how many stories I know and stories of my own of sort of not wanting to seek healthcare because of some ancillary concern around being discriminated against in a sort of a healthcare setting, or even just sort of not being comfortable in a healthcare setting. There's something that we joke about that we call trans broken arm syndrome, which basically means that, especially if you're sort of visibly recognizable as a trans person, seeking care for any other issue, for example, broken arm, as soon as the doctor learns or understands that you're trans, your medical issue becomes entirely about that, right? I always remember an experience that I had going to a dermatologist where the dermatologist basically said, he can't help anyone who takes hormones, essentially. That sort of thing. And then identity documents are also a pretty just like universal issue. Usually there's some sort of formal process for corrections. There are certainly jurisdictions where there's no process for one or many of them. In Illinois, at least, the name change process is a court petition with a publication requirement, meaning that in most instances, you have to publish your name change in the newspaper, which can be a safety issue. For driver's license changes, there's a Secretary of State form. There's no, as of recently, there's no medical documentation required, and there is an X gender marker available. With birth certificates, there is a requirement for a direct declaration from a medical provider, but the declaration only has to be clinically appropriate treatment, and that's sort of left open as to what that means. Excuse me. And then birth certificates are tricky because they're based on the state where someone's born, right? So you could be dealing with somebody in Illinois who was born in a really bad state with a really bad policy, not a bad state, but a state with a really bad policy on birth certificates. The relevant policy is going to be the one in the state that they were born. And then finally, for more complicated issues or issues that are just sort of rapidly developing, or honestly, just in general, on even the simplest of issues, anyone sort of in need of information or resources about their rights or legal processes, even practitioners representing transplants can contact our help desk, which is staffed by help desk attorneys. And I just wanted to leave as a closing slide the information for the help desk in case anyone needs it in the future.
Thank you, Nora. So unfortunately, one of our speakers had an emergency. Our speaker who was going to talk a little bit more about cultural competency. And so we are going to kind of wing it, and if anyone has any questions for Nora about these cases or LGBTQ clients, I think that we're hoping we can use the time talking through some of that, or also even more of a discussion about LGBTQ cultural competency. So if anyone has any questions, I'll pause now for folks to ask any questions. And one in the chat, Nora, they asked about a copy of the materials. We can provide those afterwards if you're okay with that?
Absolutely, happy to do that.
Great. So we did get one question in the chat, or I did, which was, and you touched on this with the transgender laws barring children from, there's a lot in the news about them competing on athletic teams with their gender identity. Can you talk a little bit more about the legality of those laws? And I think that those have been in the news more than almost anything lately, and kind of the competing kind of legal issues there.
Sure. I mean, I think with the caveat that I'm no expert on those issues. I haven't worked on any of the sports ban cases, but just from sort of my basic understanding, there are two, I think probably the two most prominent legal issues are whether, a state that bans young trans women from school sports violates, a relevant equal protection principle, whether federal constitution or state constitution. And then also, I believe that the Biden administration has sort of signaled that its interpretation of Title IX prohibits that kind of discrimination as sex discrimination in student athletics. And I know that they filed, the DOJ filed a statement of interest in Lambda Legal's West Virginia sports ban case, sort of laying out the federal government's understanding of the legal issues. So, I mean, those would be sort of the basic grounds of, for challenge on the basis that they're discriminatory. I think it depends on the exact form of the law too. Many of them ban only young trans women from school sports. And, we can sort of see why that's discriminatory when such policies the purported goal of the law is sort of fairness on a sort of a medical transition basis, but those laws often have nothing to say about young trans men who may or may not have medically transitioned, continuing to compete in women's sports. I think there's a great documentary about a few young trans athletes that came out recently that follows sort of the story of a few young trans women in Connecticut and also Mac Beggs, a young trans man in Texas. And I think those stories kind of highlight that analysis of sort of why many of these policies are discriminatory. There are also laws I know that the law in Idaho and I believe the law in West Virginia, though I'm not totally sure about that, often contain policies, provisions that give a private cause of action to anyone who feels that they have been harmed by these laws. And I think sort of the most egregiously discriminatory aspect of many of these laws is that very thing. It basically allows anyone who feels that they've suffered a competitive harm to challenge the gender of anyone who they sort of suspect of being transgender on their team, file an action in court. Often there are provisions that, at least on their face, would allow for sort of mandatory sort of medical certification of someone's gender. In other words, like, mandatory inspection, basically, by a medical provider. I think we can all see why those are sort of gross invasions on privacy, why they necessarily involve sex stereotyping, right? If you, I think one theme that we've seen is that as often as trans women are sort of challenged under these policies, sort of gender nonconforming cis women are also challenged, right? So I think we could see how, although we don't have a ton of experience to go on because these laws have only barely just come into effect, it's not hard to imagine sort of a member of a team challenging the gender, the sex assigned at birth of a teammate or someone on an opposing team who they consider to be just a little too masculine presenting, or who they sort of suspect without knowing to be transgender. We also got a really clear example of that with some of the testimony that was provided in one of the state legislatures by a young woman on a sports team who basically said, like, look, this has happened to me. My team was beaten by a team that had a trans woman on it, and reporters looked into that claim and found that the person in question was actually a cisgender woman who had a little bit of a masculine presentation. And I think, if one of these laws had been enacted in that state, clearly this person would have had a route to potentially challenge that person's gender incorrectly. So, there's lots of sort of right ground for constitutional arguments on sort of equal protection and privacy grounds as well.
Thanks. And then there was another question that in the chat from Carly that Carly works with domestic violence victims, and are trans women protected under VAWA? And if not, is there any legislation or policy that's trending towards expanding VAWA to include trans women?
I'm certainly not an expert. My understanding is that they are, if only because I remember reading that in the renewal fight in Congress for VAWA, there were people who opposed renewal on the basis that they wanted it to explicitly not protect trans women. So that implies to me that either it does already explicitly protect trans women, or that it's sort of left open but implied that it does. But I certainly defer to domestic violence and immigration experts on that question.
And then Mario, you chatted that you had a question.
Yes, so I was wondering if you knew anything about documentation and gender spectrum, so those who are non-binary or don't fit within the binary. Is there a process for documentation, or is that even a conversation right now?
Yeah, it's definitely a conversation, and in Illinois, ex-gender markers are available on driver's licenses, I believe. That obviously won't be what everybody wants, but for those who want it, it's available, and it's certainly not mandatory. And some states have followed similar policies. I know in California and in New York City, similar gender markers are available. And then I believe recently it was announced that the federal government was going to start allowing for them on US passports, which is a pretty huge move considering the influence that might have. Actually that was in part in response to a Lambda legal challenge to the existing policy on behalf of a person who identifies both as non-binary and intersex. And so, we can see why gender markers harm both of those populations. Yeah.
I had a question about the criminalization aspect of some of these anti-trans laws that you had talked about. I have a background in criminal defense, so this seems, it's all bonkers, but that seems particularly kind of out there to me. And I was trying to think, like, where else have we done that? or has that happened in the United States? And one of the only other issues I can think of where that has come up prominently is in abortion legislation, I suppose. So I'm wondering if there are any other historical parallels and if those are helpful, or if cases involving those parallels have been harmful to the efforts to increase trans rights. And then if so, if they are helpful, have there been any sort of joint efforts among pro-choice or even like the criminal defense bar? I can imagine criminal defense attorneys are not wanting to take these cases or take up these cases with such sort of wonky legislation. I know I asked you like 5 questions in that one question, but.
No worries. Hopefully I can manage at least, a cogent answer to one of them in whatever jumble I provide. But I think in terms of like historical analogs, I think you're absolutely right. Reproductive rights and reproductive justice is probably the most prominent example. And there has been, I think an encouraging amount of sort of crosstalk and coordination between sort of reproductive rights and reproductive justice and sort of those of us trying to combat these anti-trans laws. Because, they sort of are historically related, and also, I think they're overall part of the same kind of social and moral project in many ways. I think one probably, I think the same sort of dilemma comes up in both, right? Which is that at a certain level, when sort of opponents of either transition care or, reproductive rights recognize that there's a certain amount of leeway that they have to give because public opinion has sort of shifted away from them, they'll stake out sort of marginal positions, right? To sort of have an entryway, have a wedge into sort of saying, well, okay, maybe we understand that people aren't willing to accept broad criminalization of abortion and broad criminalization of medically necessary healthcare, but we can all agree that, for example, that care isn't appropriate for X group of people, Y group of people, Q situation, that sort of thing. And I think adolescence is sort of a commonality maybe there, in which both anti sort of abortion advocates and anti-trans advocates both sort of stake out that middle ground, right? Of like, well, let's start by criminalizing abortion for people of a certain age, and criminalizing transition care for people of a certain age. So I think that's sort of a common thread. And then in terms of just these criminalization laws more broadly, like they're all very different, and I think I've paid more attention to the ones that haven't passed than I have to the ones that have been enacted. But I think one clear example of just how bonkers they can be is that, as you said, is that usually they ban referrals, right? Which is just the act of saying, I can't help you, here's someone who can. And I think, it's wild to imagine that that simple act would be criminalized in any kind of regulation of healthcare.
Sorry, just one follow-up. Are doctors pushing back? I imagine they don't like being told like that they can't help their patients.
Absolutely. We've definitely seen pushback from doctors. We've seen often doctors are plaintiffs in cases challenging those kinds of laws. There hasn't been a ton of litigation on the criminalization front because those laws have only just gone into effect a few weeks ago, but definitely doctors are especially doctors that provide, both doctors that provide transition healthcare and doctors that just happen to see a lot of trans patients, right? Even if they don't provide gender affirming care, if transition care is criminalized, that's going to affect the health of their population. It's going to affect the number of people that are coming through their door. It's going to affect their resources. So we've definitely seen pushback from the medical profession as well, in sort of the effort to defeat these laws.
And then I got another question from Vivian in the chat. Is Lambda Legal involved in advocacy regarding unnecessary surgeries performed on intersex minors?
So we are definitely involved to a certain extent. I think, you know, there's a lot more work that we and other organizations could be doing. We mostly have done advocacy. You know, one sort of route that work has taken recently has been both advocacy to sort of get hospitals to end or at least mitigate the policies that they have regarding intersex infants, as well as there's been a little bit of sort of legislative work, mainly in California, which is where my office currently is located in Los Angeles. I work remotely, but that's sort of my the state that I work in or out of, and sort of there's been a lot of policy work related to not sort of outright banning that, but at least as a first step of sort of discouraging it, or you know, sort of enacting laws that wouldn't totally prevent it, but would at least cause hospitals and medical providers to sort of take a second look.
So I have a question for, in terms of looking at case decisions, is there one, in your opinion, you would point to as kind of the most favorable regarding trans rights? And then at Lambda, do you all kind of communicate around the country or with community groups to kind of look at what's pending? And how do you decide like what your strategy will be with some of these issues, or what you think might be coming up?
Yeah, I mean, I think it's hard to say if there's a case that's like most favorable. I think probably the most important in recent history just has been Bostock, just because of the broad influence that it will have, and also just sort of the fact that it's a Supreme Court case on a sort of interpretation of a statutory provision that appears everywhere, right? Like sex discrimination protections are everywhere. That's definitely important for us. And yeah, I mean, strategy is a difficult question. You know, I think there's always a tension between what you know, what is going to be most effective, and what is going to what is sort of most urgent, I suppose. And I think you're always negotiating that tension, and yeah, you just have to sort of look at you know, when are you sort of striking the right balance between pushing the needle and not taking too much of a risk. I think those are the two dynamics that are you know, most present in any kind of strategy consideration, especially with like challenging state laws and federal laws.
And for people who might be, you know, working in legal aid or more individually with cases and pro bono, if they're, you know, maybe not working on kind of the big picture, like some of these impact organizations like Lambda is, are there certain things that are helpful for them to kind of look for if they see patterns or just different issues? Or what's kind of a good way to stay on top of those things? Because you might be, you know, in a housing case or in a public benefits or a healthcare space, but wanting to be able to contribute to a broader fight sometimes as well.
Yeah, I mean, I guess I would just say, you know, little instances of discrimination pop up everywhere in all contexts. And so, you know, I think as long as we're all on the lookout for those and, you know, we can recognize them when they happen, it's an opportunity to either, you know, either that's an enforcement issue and we can, you know, easily get someone the relief they need, or it's a larger issue and it's going to be a larger fight, and maybe that will reverberate to the benefit of more people. You know, it's never a bad thing to have a really low, you know, a low commitment in terms of like time and resources, ability to just sort of get someone the relief they need based on protections that are already really strong and clear. And if that's not happening, then hopefully it should be an easy fight to get it there.
Any other questions or in the chat? Folks can include their questions as we're wrapping up.
I had sort of a last maybe wrap up question. What in Illinois specifically, what's the biggest policy push right now for trans rights, and what are the biggest concerns in terms of policies happening right now? Or things, or if maybe those are too stark of categories, just things that public interest and pro bono attorneys should be aware of, policies happening right now as we deal with our cases.
Sure. I mean, I think I'm sort of more familiar with like moves that have happened recently. I'm sort of in the process of I grew up in Chicago basically, but I'm sort of in the process of reacquainting myself with the Chicago legal landscape and the Illinois legal landscape. I know, you know, a recent issue has been identity documents, to be sure. There's been a ton of movement on it in the past calendar year or 2 years. But I know, you know, in the first instance, Illinois recently enacted some pretty good policies, but you know, there was a fight over, for example, gender markers on, I believe it was marriage certificates, and I think also being listed as the parent on a birth certificate. There was recently some advocacy around that was, I know it was sort of a struggle, but I think that those landed in a very good place. And I know that there's also, you know, always an ongoing conversation about, in Illinois as in everywhere, about sort of sex work, which is an issue that overwhelmingly, you know, disproportionately affects trans women and trans women of color in particular. And I don't know what the current sort of state of that advocacy is yet in Illinois. I know my colleague in the Chicago office at Lambda, Kara, is deeply involved in that, but I'm not as familiar.
Well, thank you so much, Nora. I can't thank you enough for, you know, you had your planned section and then answering all our questions, especially with one of our speakers not being able to show. So huge thanks to you. I like to say dozens of muted claps for you for our seminar. Thank you so much.
Happy to help. Thanks for having me.
Yeah, thanks again for being here. For those attorneys who are here as part of the CLE series, just another reminder to click on the link to do the evaluation. That's the easiest way to track your attendance. You select the CLE from the drop-down menu at the top, and then we will be sending out certificates next week, and make sure to get all those to you. We can also send out the materials from the PowerPoint, as well as any other resources we might have. This concludes the virtual CLE series from February through July. So thanks to everyone who has joined us, and stay tuned for further CLE opportunities as well. Again, we ask that if you can, you provide some sort of pro bono commitment for us or any of our partners as part of attending the free CLE series. But we are excited about our topics, and we continue to investigate what kinds of things will be helpful to you all as pro bono attorneys, as we know that there are many different client populations that we are interacting with. So thanks for this important topic today.
Yes, and thank you to all our interns and fellows who joined us. Next week, we have our evaluation session, which is just for interns to share about their experience so far this summer, and hear from others about you know, what they're doing at their agency. And then we'll be back with everyone for our hot topics in legal aid session on August 4th at noon. And we just announced what our hot topic will be, which will be the Free Britney movement and guardianship in Illinois. So hope you all join us for that on August 4th. And thank you everyone for joining us today.
Yes, thanks. We're glad we could have everyone together today. It was a unique opportunity.
Take care.